This installment of Washington Legal Foundation's Legally Brief features Scott McCowan, a partner with the law firm Oblon Spivak, who will share his thoughts on how new post-grant patent proceedings might impact litigation brought by so-called patent assertion entities, also sometimes called patent trolls. Scott, when do these new post-grant proceedings take effect, and how will they work?
Sure. As most people know, the America Invents Act was enacted into law on September 16, 2011. The vast majority of the provisions in the America Invents Act do not go into effect until September 16, 2012, 1 year after enactment. So we are now on the eve of that 1 year anniversary, and the new proceedings, the so-called post-grant proceedings that are new to the office, are post-grant review, inter-parties review, and a special flavor of post-grant review known as the Transitional Program for Covered Business Method Patents, which is a very long way of saying there's a special type of post-grant review that only applies to business method patents.
So how are the new proceedings going to be different from the post-grant proceedings that existed prior to the America Invents Act?
Currently, the post-grant proceedings that are used for challenging the validity of a U.S. patent are known as patent reexamination proceedings. Congress is moving away from the reexamination model in presenting post-grant review and inter-parties review. The main changes are when presenting these challenges to the United States Patent and Trademark Office, the challenges no longer go directly to patent examiners, but instead go to the new Patent Trial and Appeal Board. So some of the major differences right off the bat are procedural. Patent examiners are no longer involved. 3 technical judges of the Patent Trial and Appeal Board will conduct these proceedings. Another important procedural change is that these proceedings by statute must be concluded within 12 months or 18 months if the office is able to show cause. But the office has stated publicly that their intention is to finish these proceedings within 12 months' time and then possibly go out a week or two here or there if it's an incredibly complex case, for example. So the big difference between patent reexamination and the new post-grant proceedings is really speed. On the substantive side, the criticism of patent reexamination is that it's only for patents and printed publications. So the reason there are multiple types of post-grant proceedings is that depending upon the evidence you wish to present to the office, that will dictate which one of the proceedings you will use. For example, inter-parties review, very much like inter-parties patent reexamination, which it was designed to replace, is only patents and printed publications. On the other hand, if you want to bring in evidence as to on-sale bar, public use, indefiniteness, statutory subject matter, the types of additional defenses to a patent assertion that you might otherwise bring in a district court, you would have to bring post-grant review proceeding. But the important thing to keep in mind when choosing between the two is post-grant review is only for the patents that will issue under the new first inventor to file standard. So this choice is not really a choice for another few years. Right now, as of next month, September 16th, the choice will be inter-parties review or the transitional program for covered business method patents, which, as the name implies, only applies to a certain type of technology.
Now, you've written in some of the commentaries that you've done on this that these new proceedings might be useful to defendants being sued by patent trolls, patent assertion entities, whatever you like to call them. How exactly are they going to be helpful to those kinds of defendants?
Right, that's a good question, and I think it's largely overlooked as to the impact of these new post-grant proceedings. When a patent troll approaches a company today, you have to understand the business model of the patent troll to really unravel the problem. So the business model of the patent troll is that a licensing company, which does not manufacture, create any products, purchases a patent and then starts to assert it against companies that do produce products as a means to create licensing revenue via lawsuits. So the license company has no business that is subject to a countersuit on a patent. So they go out and they retain a law firm, typically on a contingency basis, and they begin to sue major companies. So as you can imagine, with the cost of litigation being so high, the leverage of creating that expense for a company against a company is a tremendous motivation to settle, even for the most questionable of patents. So rather than spend $3 to $5 million to trial, it's easier to simply pay some nuisance settlement, $100,000, $200,000. And when you take that model and multiply it by 50 defendants, it becomes a very profitable business for a patent troll. So in an effort to unravel that problem right now and try to find an alternative to litigation, what folks do is they file patent reexaminations. The problem with patent reexaminations is that they take too long, so years and years. So it really is not a problem for the patent troll because by and large most courts will not stop the litigation in view of a patent reexamination. Some will, but it's not a guarantee. So the new proceedings, having the condensed time frame of a year, change that calculus a little bit. So when you go into the court and you argue to the judge that the case should stop and wait for the patent office work to conclude, you have the additional advantages to say it's not a 4 to 5 year pendency, it's 1 year. These patents are going to technical experts, 3 technically trained judges that have to, by statute, conclude within 12 to 18 months. So that's a bit more, that's a stronger argument as opposed to what you do now when you go into court to say, let's stay the case. It could be stayed for 4 to 5 years, and then there's the argument that this is prejudicial to the patentee. Those types of arguments will now essentially disappear as of September 16th.
Do you think that the International Trade Commission, which also has statutory deadlines to conform to and has been pretty hesitant to put its cases on hold in the past, will be more likely to put its proceedings on hold for these more accelerated proceedings?
Right. So getting back to the speed issue, when you're attempting to stay a district court litigation or an ITC case, the length of the patent reexamination proceeding is almost always the controlling factor that is influential to the judge. And this is especially the case in the ITC, where they have their own statutory mandate to conduct things and finish things as soon as practically possible. With the ITC concluding their actions within roughly 15 months' time as compared to the old reexamination model, which takes several years, it's not surprising that the ITC almost never stays a case for patent reexamination. Now, going in there with the much quicker USPTO timeline, that's an additional factor that may sway the ITC to start thinking about things a little differently. A second factor is previously with reexamination, inter partes reexamination, there was statutory estoppel to the challenger. So in a district court, you could argue that either the patent would fall, which would moot the case, or if the patent didn't fall, the defendants would be restricted in the types of arguments they could make at trial. So in other words, waiting for the outcome of the PTO had a great potential to simplify the issues. But that estoppel did not apply to the ITC. So in fashioning the new post-grant proceedings, Congress added ITC into the estoppel mix. So there's an additional argument there that wasn't there prior to the enactment of the American Invents Act. So I do expect the ITC to begin staying cases, perhaps especially for patent trolls that are now flocking to that agency in an attempt to get away from other district courts that may stay proceedings pending patent reexamination. The ITC, especially for patent trolls, may start to think a little differently about staying cases.
That was great.